All right. My name is Raúl Macías, and I'm the Democracy Program Director with the Evelyn and Walter Haas Jr. Fund. And I'm very glad to be with you all today. And I'm honored to be moderating this conversation with this very distinguished group of speakers. I want to thank the Asian Law Caucus, California Common Cause, ACLU of Southern California, and PANA for organizing this event. Today marks the 60th anniversary of the Federal Voting Rights Act and the 50th anniversary of the expansion of the VRA to include language services. So we're going to be talking today about how this landmark law and its subsequent expansion has helped to make our democracy a more inclusive one. We have a group of experts who are going to walk us through this section of the Voting Rights Act and how the law has evolved over the last 50 years. And we'll hear some firsthand history of the efforts to pass renewals of the law and some examples of its impact. So first, let me introduce our speakers. First up, we'll have Angelo Ancheta. He's a senior research and policy counsel at Demos, where his work focuses on voting rights, language access, and state and local democratic reform. Angelo has over 3 decades of experience working as a community-based lawyer, nonprofit manager, academic, and researcher. Welcome, Angelo. Then we will have Jim Tucker. Jim is an attorney in the Department of Justice's voting section. He has extensive experience teaching, studying, writing, and litigating in the field of voting rights. And this includes an emphasis on Section 203 of the Voting Rights Act and Native American voting rights. Good morning, Jim. Following Angelo and Jim, we're going to have a panel that includes Rosalind Gold, Henry Durr, and Karen Narasaki. Henry is a San Francisco civil rights leader and activist. He served as executive director of Chinese for Affirmative Action for more than 2 decades, as well as deputy superintendent of public instruction for the California Department of Education. Welcome, Henry. Rosalind Gold is the Chief Public Policy Officer with NALEO Education Fund, where she has worked for more than 3 decades on policy analysis and research for the organization's naturalization and Latino civic engagement efforts. Rosalind has extensive policy expertise in the areas of newcomer civic integration, election reform, voting rights, redistricting, and the decennial census. Welcome, Rosalind. Good to see you. And finally, Karen Narasaki is a national civil and human rights leader. She is the former president and executive director of Asian Americans Advancing Justice, and previously was appointed to and served on the U.S. Commission on Civil Rights. So welcome, Karen, and thanks for being here. Okay, well, I'm really excited to dive in, but first, just to give everyone a couple notes, we're going to be taking questions at the end, so please send your questions. There's a Q&A box. I think you can find it by clicking more at the bottom of your screen, that more button, and then you'll see a Q&A option. You can put your questions there. We'll be collecting those and saving those for the end. And then second, if you enjoy what you're hearing today and want to learn more, I hope you'll consider joining us at a Language Access Summit that the organizers of this webinar are hosting in Sacramento on August 26th. There's a very distinguished group of speakers for that event, including Secretary of State Shirley Weber and former Attorney General Javier Becerra. And there will be advocates and researchers from across the country that are coming. And it should be a great event, so I hope you'll consider joining. There are travel and registration stipends that are still available for those who need them. And yes, there's a link in the chat where you can use that to learn more. Okay, so we're going to start with a presentation from Angelo that's on an overview of this area of the law. But first, we're going to share a short video that was created by Asian Law Caucus about a couple of voters who have benefited from language services. So let's cue that up now.
미국 시민이 된 것이 자랑스럽게 생각하고 투표를 할 수 있고 거기에 대한 어떤 자부심이 있었어요.
선거 용지를 받았을 때 첫째 이 불안하고 긴장되고 내가 영어를 잘 못하기 때문에
그것을 다 이해하기에는 시간이 많이 걸렸습니다.
자식들한테 물어보고 남편한테 물어보고 사전을 찾아보고 매우 아주 어렵고 힘들었습니다. 저는 너무너무 좋아서 황홀감까지 느꼈습니다.
많이 이해할 수 있어서 참 좋았습니다.
내가 참 선거를 할 수 있고 책임과 의무를 다하는 그러한 역할을 할 수 있다는 것에 대해서 자부심과 보람을 느꼈습니다.
투표를 하면서 아, 나도 이제 미국인이 됐다 하는 그 소속감을 느꼈습니다.
Thank you. Okay, that was a great way to kick it off. All right, I'm going to pass it to you now, Angelo.
Great, thank you, Raúl. Thank you to the organizers and to Raúl and the Haas Junior Fund for supporting this webinar and also the upcoming conference. I'm really excited, not just as a participant, but to hear people. This is about as esteemed and well-versed a panel as I've ever been on. So I'm happy to give you sort of an overview of Section 203 and some of the basics. So why don't we go to, this is my contact information on deck right now. But let's go to the next slide, please. So I'm going to cover a couple things. One is a sort of a basic sense of what the language needs are nationally. And then I'll talk more specifically about Section 203. And I might have a few things cut off here, at least on my screen. I'll just mention them. So we're going to cover some specific areas of Section 203, including coverage and requirements and compliance. And there's a little bit of social science data. I think that bullet got cut off, but I'll talk about that at the very end of this initial presentation. Okay, next slide, please. So just to give you a sense, these are national numbers, and obviously this can vary quite a bit based on your locality. But if you look at the national numbers, there are roughly about 67 million people who speak a language other than English at home, and of these, close to 40% don't speak English very well, which means they're limited English proficient, LEP. So that's about 25 million people. And again, just some particular numbers here. Spanish speakers, 40% roughly LEP. Some of the Asian languages, over 50% are LEP. Okay, next slide. Okay, so Section 203 is one of several language access provisions in the VRA, but it's important to note that language has always been a basis for discrimination. And part of what's going on with Section 203 is that it is trying to remedy both past and present discrimination, not only in the electoral process, but also in education, because the predicate for a lot of the work that's being done to provide language assistance arises out of educational discrimination. So we know there's been a history of using things like literacy tests, English-only requirements intentionally to try to discriminate against minority voters. But in 1975, and we'll talk more specifically, obviously, because this is the anniversary, the VRA was amended to add the language minority classification. And this is not just related to language assistance, but also just more broadly to cover or to ensure that there's clear coverage for particular groups. So Latinos, Asian Americans, various Native American populations were added to specifically cover multiple parts of the VRA, but in this case, to provide language assistance. So Spanish, certainly, and then multiple languages under each of those subgroups. Okay, next slide. Next slide, please. Thank you. So Section 203 is the major one we're going to be talking about. So it is a major provision that provides language assistance where mandated and where covered in various local jurisdictions, a few states as well, statewide. Just to round out a few things, there are a couple other provisions there related to language provisions for Puerto Rican voters. That's often the basis for some significant litigation in a few places. 4F is another remedial statute. And then Section 208, I'll just simply mention here, but that's a provision of the VRA that allows voters to bring assistants into the voting booth with them. Could be a friend, could be a relative, and they can actually have someone help translate or help them vote actually in the voting booth. Okay, next slide, please. Okay, a little bit of cutoff here, so we'll just try to work with that, what's at the bottom. So there are specific tests that are applied to determine whether a particular county, typically, but also for states and also cities and towns. But the basic requirements look at a set of numerical or mathematical benchmarks. So in the original 1975 legislation, it was a percent-based rule. So if you look at 5% of all the voting age citizens in a jurisdiction who happen to be limited English proficient, and this is calculated by census numbers, and they're within a particular language group, then they can be eligible for Section 203 coverage. As you'll hear from other speakers, that test was amended later on in the 90s to add a flat absolute number benchmark. You could be covered for both, but if the 5% rule isn't triggered, you might have a sufficient number of LAP voting age citizens if there's 10,000 or more within a particular jurisdiction. And again, you have to look at the English proficiency. Are they LEP? And you also look at literacy levels to see if the illiteracy rates are above the national average. In other words, more of these particular voters or potential voters are have less education than the national average. Okay, next slide. Okay, so the 5% test is used for states. So there are a couple states like California, Florida, Texas, where they are statewide required to provide language assistance. There are special rules for indigenous languages and indigenous populations. If there's more than one town within a particular area, it could be a reservation, it could be a AIAN area, which are determined by census numbers and other federal law. All of those jurisdictions are actually covered. Now, just an important note, if you fall below one of the benchmarks, below 5% or below 10,000, you don't qualify. You don't have, the jurisdiction does not have to provide any kind of assistance. So you could have 9,999. That isn't sufficient. Maybe it's involuntary efforts, but it's not a requirement under Section 203 to provide assistance. And typically, jurisdictions don't provide that assistance to groups that are below. They do make determinations every 5 years. That's a fairly recent amendment to the law. It used to be every 10 years. And they rely on various data from the census to put that together. The last determination was in 2021. So those are locked in for at least for the next year or so. And then there'll be a new set of determinations probably late next year. It's important to note that you can pick up languages or pick up new jurisdictions. You can also lose languages or lose jurisdictions because the numbers go down. So it could be they fall below 10,000, or what's common is that the 5% rule, the relative percentage goes down for a particular group. It goes below 5%. Okay, next slide, please. Okay, I'm not going to go through any detail here, but as you can see, several states in the United States are covered. A couple of the ones in blue, not the Great Lakes, of course, but the 3 states below are covered as statewide 5% jurisdictions. And we'll talk a little bit more about specific places. Okay, next slide. Okay, oh, we have some major cutoffs here. Okay, I'm going to look at my copy here and give you a sense. So if you look at Queens County, oh, there we go. Yeah, so Queens County in New York, there we go. That's better. Thank you. So Queens County has 5 languages. LA County has 6 languages. Dallas County has 2. Just as an example of some interesting coverage, Kodiak Island Borough in Alaska has Yupik, which is an indigenous language. Also has Filipino. A lot of folks who were in the cannery and fishery industries from the Philippines reside in that borough, and they're still there after several decades. Okay, next slide. Okay, so what's required? This is just a sample of things that are typically required. There's a long list of specific requirements that are in Justice Department guidelines, but translations of materials, not just ballots, but also sample ballots, information materials. This can be very important, particularly where in states or localities where there are direct democracy initiative language has to be translated. There are many languages where there isn't a written tradition, so you have to provide oral assistance for those voters. Bilingual poll workers is another requirement, and very common. And just signs, various kinds of poll information. So basically everything that a voter really needs to have an informed vote needs to be translated into a covered language. And this is the basis for a lot of challenges too. So we'll talk about that in a bit. Next slide. Okay, so again, problems, sometimes things aren't translated properly. Mistranslations are not unusual. Sometimes the number of materials, they may translate ballots, but sometimes you don't translate enough informational materials or voter information pamphlets. Recruitment of bilingual poll workers may not be sufficient. There may be insufficient training of poll workers who are in larger are precincts with high populations. New jurisdictions, because every 5 years you make it new jurisdictions who haven't done it before. That can be an issue. Even those that have coverage, they may be adding 1 or 2 new languages, and they're not quite prepared to add those languages in a more complete way. The enforcement mechanisms, the DOJ, the voting section of the Civil Rights Division, is supposed to be covering a lot of the both compliance and also engage in some degree of monitoring and litigation as needed. That can vary. It's not always by party or who's in the White House. There's often been, for example, strong Republican support under the second Bush administration for Section 203. But that's a big concern, to be frank, about the current administration. How much is the DOJ going to be really on top of things? There are ways for individuals or classes of individuals to sue under a private right of action. That's also at risk. If you're in the Eighth Circuit, it hasn't been quite litigated, but probably you're not going to be able to sue in that particular circuit. And there may be bigger challenges as we see courts, including the Supreme Court, address the VRA's private rights of action. Next slide, please. Just a little bit, obviously that video was very powerful. I think it's great to hear in just a couple of voters who it's really made a difference in their interest in voting and their actual voting and their ability to vote with an informed sense of what am I responsible for. But there are just studies that have come out both at the local level in terms of local jurisdictions. There also some academic studies. I'll just refer you to one report that came out not too long ago, looking at Asian Americans and Latinos. So positive, very strong positive effects in terms of voter registration, very strong positive effects in terms of voter turnout. So it's clear that, again, whether you think of it anecdotally or you look at it more systematically, Section 203 has had a positive effect on voters, that they're able to vote in their first language, and that it encourages them to not only to register, but also to turn out to vote. Okay, I'm going to leave in the chat a report that my office put out last year, which is if you want a 50-page discussion of all the stuff I just covered in a few minutes, that report covers several topics. And that'll wrap up my session. I'll be back in a little bit towards the end to cover some state and local stuff, but it's my presentation. So thank you.
All right, thanks for that overview, Angelo. We'll see you in a bit. We're going to pass it to Jim next. He's going to, and do we have his slides ready? Okay, Jim's going to walk us through the evolution of this law and talk a bit about how it's enforced through litigation.
Thanks so much, Raúl. So while they're putting the slides up, I will just have a couple of quick things to say. First of all, disclaimer, I am giving this presentation in my personal capacity, and the views expressed herein do not necessarily reflect those of the U.S. Department of Justice. The second thing is I want to also commend Angelo for a great introduction, and also just add on to his thanks to both the Haas Foundation, California Common Cause, and all of the other organizations that have made this possible. So with that, next slide, please. So I'm just going to go through a few slides very quickly at the beginning just to show you illustrative, roughly how many people speak a language other than English. Next slide, please. Unfortunately, these don't need, you may need to pause here for just a second just so you can see, but you can just see that it's a nationwide issue, that limited English proficient voters are in every part of the country. Next slide, please. And then this just gives you a census map, kind of what we call a choropleth shaded map that shows you just where you see large numbers of LEP voters. Not surprisingly, you tend to see them in border areas. You see them in urban areas where you have larger numbers of migrants. And then, of course, a lot of the interior areas that you see are areas of Indian country, but also oftentimes, especially in the Plains states, you'll see a lot of Spanish speakers as well. Next slide, please. And again, this just shows you kind of changes. Next slide, please. Okay. And then not surprisingly, when you see the states that are covered, just remember the purple states, and it will make sense that this is why those states also tend to have fairly high levels of coverage. Next slide, please. So I'm just going to cover briefly, build on what Angelo had discussed, and talk about the changes in 203 over time. Next slide, please. So this will give you a bird's eye view of how it's changed from each set of determinations. And there are going to be reasons for that I'll be able to go through briefly to explain. You can see obviously that since 2002, both California and Texas have been covered statewide for Spanish. New Mexico briefly was during one round. And then in 2011, they were replaced statewide by Florida, which has been, like California and Texas, each of the successive determinations. Next slide, please. So this is the original coverage in 1977, and you can see it was very, very broad. Part of the reason for that is that they used a slightly different coverage formula. It was a 5% citizen voting age, which means U.S. citizens over the age of 18. It did not include a limited English proficient requirement. So we're going to go to the next slide, and we'll see what happens when they added that in. You can see a dramatic decrease in coverage. And the reason is, if we go to the next slide, Senator Don Nichols added an amendment in 1982 that kind of went below the radar, that added a limited English proficient requirement. And that's currently what we use for all of the coverage formulas for all three of the triggers. And whenever you hear me use, or anyone else use the word trigger, we're referring to coverage formula, not a gun, but a coverage formula. But this will give you an idea. And again, the Nichols Amendment really dramatically cut in. It was basically a reduction of about half of the number of jurisdictions that were covered. Next slide, please. And again, this just reminds you in 84, like what it looked like. So next slide, we'll go to the next round in 92. So 92, you see a fairly significant increase in the amount of coverage. And I'll just leave it there briefly so you can look at it. And the next slide. The reason is because in 92, this is the only time that this has happened in 203's history. The 92 amendments to the Voting Rights Act only focused on Section 203. The reason is because when Congress extended the provisions, the Section 203 is a temporary statute. And so in the 1982 reauthorization, Congress had only extended them for 10 years and had to revisit them in 92. It was fortuitous because it gave members of Congress an opportunity to improve the formula, and that added in the two additional formulas that Angelo had mentioned, the 10,000 limited English proficient voting age citizens, which especially affected urban areas. You would have areas, just to illustrate, you would have an area like Los Angeles, where Los Angeles County, you would never be able to meet the 5% citizen voting age population requirement or LEP requirement, because you could have tens of thousands of people who are limited English proficient, but they might only make up 2% of a very, very populous county. And so that corrected that particular problem. The other issue was one that Angelo pointed out, the reservation trigger. It basically applies the 5% formula to reservations. So what it means is that when you have reservation bridging across multiple counties or states, each of those places where there's a portion of the reservation is also covered for that language. Next slide, please. So this is the 2002, just shortly before reauthorization. And again, you can see fairly broad coverage. And again, this is even after the LEP. You can see that jurisdictions are being added back in, even with the limited English proficient requirement. And then the next slide, please. And this takes you to 2011. It's odd because look at all the places that you see losing coverage. The one that stands out most for Indian country is South Dakota went from 18 covered counties to 0. And there is a reason for that. That was kind of an unintended consequence of the 2006 reauthorization. Next slide, please. What happened is the Census Bureau had eliminated the long form that was used with the decennial census. They were already going to the American Community Survey. And what we didn't realize, or at least underestimated, was that the American Community Survey, unlike the long form, is a much smaller sample. The long form was sent to 1 out of every 6 households. So you could even send it to less populated areas, and you would tend to get a very representative sample and be very confident in the coverage. The American Community Survey is sent to 2.5% of all households each year. And in large urban areas or more populous counties, that doesn't really affect the coverage, but it did in some of the rural areas and less populous areas. So next slide, please. And so you can see 2016, you see coverage coming back in generally. You see some loss of coverage, but again, you start to see it improve. And then the next slide. 2021, this is the same slide that Angelo had up. You can see a lot of places being added in, and one of them really stands out is Wisconsin. You wonder what happened in Wisconsin. Most of that coverage was for American Indians, and it was because the Ho-Chunk people are there. And what happened, that the way that the Census Bureau has really improved its sampling for the American Community Survey is they oversample, which means they send out to more than the 2.5% in less populated areas. But they also resample because they want to make sure that when they are getting those results, that they're getting a representative sample for the community. And so as a result of that, over the last two rounds of coverage determinations, they vastly improved it to the point that even in the less populous areas, you see that they're still being covered. And in fact, many of them are coming back into coverage because the Census Bureau has improved its sampling techniques. I think I may have a few more slides, but I can actually skip over the balance of the slides now. This at least gives you an idea of how the coverage has evolved. The only thing I'll just say in the last couple of minutes that remain to me is I just want to point out some of the issues that we saw when we litigated for a decade in Alaska. Alaska was very interesting. It had been covered since 1975. Very large number of Alaska Native languages. They also had Tagalog covered in a few places. Including Kodiak, and nowadays I think it's also West Aleutians. And what we found was that they weren't really doing anything. Their idea of language assistance at that time was they would recruit people from the villages who obviously spoke the language, but oftentimes those poll workers did not speak English proficiently, or they did not read English proficiently. And so they simply were not capable of serving as interpreters. And then the other part of it is that they weren't being trained. They weren't being given any materials or audio translations, any aids, even for oral languages and oral language assistance. It's common that you'll provide glossaries so that you're not placing a poll worker in an impossible position of having to translate an election term that, in the case of Alaska Native and American Indian languages, may not have any counterpart at all in those languages. We ended up bringing two cases, and I just want to focus on a few things that came up in the second case. In the second case, the state took the position, a very paternalistic position, that they were solely responsible for determining what a voter needed to be able to vote. And that meant, and as it proved through some of the evidence we found, they only translated 2 out of 4 ballot propositions because they felt like the voters didn't need to know about the other 2. The other thing that they said was an astonishing argument in this day and age. They actually argued the 15th Amendment did not apply to American Indians and Alaska Natives, which is truly, truly astonishing. Not surprisingly, that case was fully litigated to a decision, and we got a bench decision finding a 203 violation. The thing I really want to focus on, because I think this is going to be a continuous theme, and it's even highlighted in the introductory video, there is a very simple standard for 203 compliance, and that is effectiveness. A single word, effectiveness. It is not a top-down view. You look at it from the perspective of the voter who doesn't speak English proficiently or doesn't read English proficiently. If they can't understand the same information that you're communicating to voters in English, it's not an effective translation. So just bear that in mind. And I think the other point I will make, and I'm sure others will build on this, in the Western states particularly, ballot questions tend to be one of the biggest areas that we have concerns with 203 compliance, because jurisdictions oftentimes do not provide adequate translations. So just bear all that in mind. I see that I'm out of time, and I look forward to the Q&A a little bit later. Thanks so much, Raúl.
That was great. Thank you, Jim. So we're going to Rosalind and Karen. Is everyone hold up? Okay, well, first we're going to start with Henry. Henry, we're hoping you could take us back to San Francisco before Congress adopted Section 203. There was an important civil rights case that came out of San Francisco and that addressed discrimination against English language learners. I'm hoping you can give us some of that background and how that set the stage for language access and voting rights.
Thanks, Raúl, and thanks to Haas Jr., Asian Law Caucus, and Common Cause for bringing us together today. In the early 1970s, CAA Chinese for Affirmative Action was very active in the Lau versus Nichols lawsuit to address the educational needs of immigrant students. In Lau, the Supreme Court ruled that under Title VI of the '64 Civil Rights Act, English-only instruction does not constitute equal education for immigrant students who do not read or speak English. Following the court's decision in Lau, California U.S. Senator Alan Cranston's office contacted CAA about the implications of Lau on the voting rights of non-English speaking citizens. Ling-Chi Wong, one of the co-founders of CAA, met with Cranston's office and advocated Title VI was vital in advancing the voting rights of non-English-speaking citizens. Senator Cranston responded positively. He then worked with Senator Ted Kennedy to include the bilingual election provisions in the Voting Rights Act of 1975. Initial implementation of bilingual elections in San Francisco County, though, was a nightmare. The San Francisco Registrar of Voters instituted a survey for registered voters to indicate their need for a bilingual ballot that both intimidated and confused non-English speaking Chinese voters. Although the registrar initially provided some bilingual materials for the November 1975 election, non-English speaking Chinese voters could not cast an effective ballot due to the inaccessibility of such materials, and there was no effort to recruit bilingual poll workers. CAA had no choice but to join MALDEF in filing a lawsuit against the San Francisco for noncompliance with Section 203. Federal Judge Lloyd Burke, who had dismissed Lau at the district court level, took similar action to quickly dismiss our legal challenge. In spring 1978, CAA successfully persuaded the U.S. Attorney in the Carter administration to investigate numerous incidents where non-English speaking voters, Chinese voters, could not effectively exercise the right to vote. By fall 1978, the Justice Department filed a lawsuit against San Francisco's failure to comply with Section 203. Assistant U.S. Attorney Amanda Metcalf mobilized and assigned federal observers to monitor voting that took place at Chinese and Hispanic precincts on Election Day. These federal observers found non-English speaking voters could not cast an effective ballot. Metcalf also secured an affidavit from an election official who witnessed the registrar of voters willfully obstructing the law, refusing to train bilingual poll workers, and referring to Chinese American voters as, quote, those goddamn chinks, unquote. In the face of this damning evidence of hate and noncompliance, in May 1980, San Francisco chose to settle the lawsuit by accepting a consent decree requiring it to implement comprehensive multilingual elections. The Nichols Amendment to Section 203 of the Voting Rights Act of 1982 technically removed San Francisco from Section 203 coverage. Notwithstanding the impact of this amendment, multilingual elections stayed in place in San Francisco in order to fulfill the provisions of the 1980 consent decree. Unfortunately, throughout the 1980s, there was a lot of public hate against bilingual elections. By a wide margin, San Francisco and California voters passed ballot measures calling for the repeal of bilingual elections and making English the official language of the state. In addition to the baseless fears about citizens who do not speak English fluently, opponents of multilingual elections asserted they were too costly and not needed by linguistic minority voters. Immediately after the November 1991 mayoral election, CAA and the Chinese American Voter Education Committee conducted a telephone survey of 292 randomly selected registered Chinese voters among more than 6,000 voters who indicated a need for election materials and assistance in Chinese. 53% of Chinese voters in this survey voted in the 1991 mayoral election, the same rate for all registered voters. We also randomly selected respondents to participate in focus group discussions. An overwhelming majority of focus group respondents read Chinese language newspapers on a daily basis, demonstrating a keen interest in news and current affairs. Close to 90% of focus group participants felt it very important or somewhat important that the availability of bilingual election materials encouraged them to vote in the November 1991 election. A similar percentage found bilingual election materials very helpful or somewhat helpful. And a third of the respondents indicated that they requested bilingual poll assistance on election day. The total cost of the November 1991 election was $1.1 million. The cost of the multilingual portion was $42,000, or less than 4% of total costs. Election officials and others had to admit that cost was no longer an issue. CAA was very pleased that we could present these survey findings and our overall experience with Section 203 to the Senate Subcommittee on the Constitution as it held hearings on the Voting Rights Act of 1992. Thank you.
Wow, thanks for taking us back, Henry. Karen, that's a perfect segue to you. And you were a young advocate back in 92 when Section 203 was up for renewal. Maybe you can take us back to that effort and what you remember from the time.
Yeah, I'll start with what the political landscape was. As many of you, well, those of you who are old enough recall, George Bush was the president. The Democrats controlled the Senate and the House. And President Bush had recently vetoed the first version of civil rights legislation meant to correct several Supreme Court decisions that had weakened anti-discrimination employment laws. Representative Jose Serrano, who is a Democrat from New York, introduced the House legislation, and the House went first, as it usually does on legislation, because they don't have filibuster to overcome as the Senate does. The amendments that were offered to undermine the proposed legislation went down to defeat, with, in fact, several Republicans voting against those amendments. On the Senate side, then Senator Biden was the chair of the Senate Judiciary Committee, and Senator Strom Thurmond was the ranking Republican. He was a supporter of segregation and a staunch opponent of any civil rights laws, including all the major ones that passed in the 1950s and 1960s. Senator Alan Simpson, though a very close friend of Congressman Norman Mineta, led the opposition efforts on Section 203. Senator Paul Simon chaired the subcommittee on the Constitution and Civil Rights, which had responsibility for the bill, and he also authorized the Senate version of the bill. It was important because his state of Illinois had large Chinese and Latino populations who could benefit from a change to the formula. John Tresvigna was staffing him, and he had written a thesis at Harvard on Section 203, as well as testified on the 1982 reauthorization. So in the communities, the growth of the Asian American population was largely coming from immigration, and the population, though relatively small, was very much concentrated in a few states, and within those states around the major cities, the largest being New York, LA, and San Francisco. So you could have a population of several 100,000 voters, as was true in LA, meeting the illiteracy and limited English proficient triggers, but still not reach 5% of these extremely large counties. Changing the formula was particularly critical to expanding coverage beyond the Chinese speakers in San Francisco. The National Asian American Civil Rights presence in DC at the time was limited to the Japanese American Citizens League and the Organization of Chinese Americans. Much of the work in the community preparing for the reauthorization, as you heard from Henry, and the expansion for Section 203 were carried out by the locally based California and New York organizations. They did the research on costs and continued discrimination in education and at the voting booth. It's very important to have this because when you base something on race and ethnicity, you need to show that it can pass the constitutional test that generally limits using race and ethnicity. And that work was pivotal to trying to get the bill passed. The Latino community was growing rapidly, but those that were citizens were relatively still concentrated in far fewer counties than today. And they were also able to benefit with a change for Chicago. For Native Americans, as you heard, the significant issue was the fact that some reservations and tribal areas cross county or even state lines. So the goal was to get coverage for the whole reservation, even if the part of the reservation in a county would not have independently been able to qualify. The hostility to immigrants had not grown to the level that it is today, but it was very present, as Henry noted. I had just joined JCL to run its lobbying office in DC, and I was motivated to do that because of a series of hate murders of Asian Americans in Texas, Florida, and California. The work to reauthorize Section 203 when I joined was in full swing, and the debate was how hard to push for an expansion in the formula for coverage, because you could potentially risk support for reauthorization. Opponents, aside from the anti-immigrant wing and the proponents of English only, were primarily election officials who did not want to have to manage a more complicated election process and were concerned about any additional costs added by the requirement since no federal funding was going to be provided. So expanding immediate coverage might add fuel to that fire. LA County election officials were particularly concerned since they could likely be covered for more than one language. And as you saw by the earlier maps, that turned out to be true. Asian Americans advancing justice in Southern California wanted coverage for communities in LA, Korean Americans and Vietnamese Americans whose communities in Orange County and San Francisco Bay had been growing as people became citizens, and also their citizen-born children were reaching voting age, also felt they could get coverage if the threshold was low enough. And ALDEF, of course, was working in New York to get coverage for Chinese Americans. We initially started with a 5,000 threshold because that would have provided faster, broader ethnic and geographic coverage, but eventually settled for 10,000. Asian American community leaders in California had a strong coalition working with legal groups such as the Asian Law Caucus, the Legal Center, the California ACLU, and San Francisco Lawyers Committee, and of course, ALDEF was working in New York. JCL worked nationally with MALDEF, NALEO, and other Hispanic and Native American groups through the Leadership Conference on Civil Human Rights, which continues to coordinate all major civil rights legislation going through Congress. Senator Simon's bill, like Congressman Serrano's bill in the House, contained the additional 10,000 threshold and also fixed for the Native American boundary issue. As in the House, the Senate voted against attempts to strike the expansion and otherwise weaken Section 203, and President Bush ended up signing the bill over 30 years ago this month. I just want to note how impactful that change was. The Terry Alminis from the Asian American Justice Center looked at the 2021 determinations, and she found that of the over 50 counties covered for Asian languages, only 9 of them gained coverage through the 5% threshold. So the other 44 counties got there through the 10,000 threshold, and they covered 80% of the Asian Americans who are receiving language assistance today. As expected, they're in the very largest counties like LA, San Diego, San Jose, Orange County, and outside of California, Houston, Chicago, and the New York City boroughs. So kudos to all of the hard work of the communities who prepared for that very significant change to the original legislation.
And thank you for your hard work on it, Karen, and for giving us that background. Rosalind, we're gonna go to you now, and you were with NALEO in 2005-2006 during when the entire VRA was up for renewals. And so, can you take us back to that effort and what you were doing at the
Great. Well, first of all, I want to echo my thanks for the leadership of Raúl and the Haas Fund, as well as thanking so much California Common Cause, Asian Law Caucus, ACLU, and PANA for supporting and coordinating this event. So in my presentation, I'm going to talk about the battle over the 2006 reauthorization by just sharing some personal stories, but those personal stories are going to illuminate some of the issues and challenges and the discussions that we had, very intense discussions we had when we moved forward with the reauthorization fight. So from the very beginning, there were just a few of us who were saying, you know, maybe we could use this reauthorization as an opportunity to cover racial and ethnic groups that are not currently covered by Section 203 of the Voting Rights Act. You know, for example, we're thinking about the Russian community or the growing Farsi-speaking community. And a few of us just kind of floated this idea. Well, there was a very immediate, strong response to this. As Karen had mentioned, to pass muster with the constitutionality of Section 203, you had to build a record that there was discrimination against groups if you were going to get them covered. And in fact, at that time, a very bright lawyer, I believe his name was Jim Tucker, wrote a memo saying, this is why adding these other groups would not be constitutional. Now, Jim, I've never had a chance to apologize to you for being one of the people who made you do that extra work. But that memo really was important because in general, we all had to work together to make sure there was strong record of strong documentation of the fact that we still had a need for Section 203, that we need to reauthorize it, that discrimination in voting still existed. And that record building, that documentation was crucial. For my second story, I want to read folks a quote, okay? The quote is, should we close the door to a ballot because of a failure in our educational system? I would answer that question, no. Well, you know, if you think about our current state of polarized political dialogue, you might be surprised that this quote actually came from the Republican chair of the House Judiciary Committee, James Sensenbrenner, who had a long record of support for the Voting Rights Act and reauthorization. And he was critical to helping us form and forge a bipartisan coalition that was needed to renew Section 203. Now, you know, some of you might associate Representative Sensenbrenner with things like an effort to make undocumented immigration a crime, and might be surprised to find that he did indeed have this strong record of support. But what his support did, as well as the hard work we did to talk to legislators from both sides of the aisle, was to basically sort of drown out some of the English-only people, some of them what we considered and marginalized Republican House members as really being extremists and not being with the mainstream of both parties in reauthorizing Section 203. And in fact, if you look at the final vote for the 2006 Section 203, it passed the House 390 to 33, and it passed the Senate 98 to 0. The last thing that I wanted to talk about, the final story, is about how we had to have several different conversations that were difficult because we had to forge unity between a very diverse coalition of racial and ethnic groups around the around the reauthorization. You know, at the time of our advocacy, you know, there were relatively small community of LEP Black citizens, and we were concerned that advocates in the Black community would not see Section 203 reauthorization as a priority. So, you know, at that time, we were not only working to reauthorize Section 203, but to also reauthorize the section of the Voting Rights Act that requires certain jurisdictions with a history of discrimination to get clearance from the federal government before making changes. So what we did was to work together to really frame the reauthorization and the reauthorization and pre-clearance and Section 203 as a package deal that would benefit all communities of color. And then the final issue that we faced was, you know, how did we mobilize? How did we work to not just make this a Washington, D.C. issue, but one that affected people in all of states? And I know that in California, we ended up forming a very, very robust and vigorous coalition of advocates. And many of the partnerships that we forged with together as state organizations have led to lasting and collaborative language access and election work in California that has laid the foundation for the changes that we have made in the state. Well, you know, when we think about back in 2006, we know now that we are facing a very, very different federal advocacy landscape around voting rights. But for us, the silver lining in all of this is that there is a foundation of partnerships we can build on, a nimbleness we can use, and we can continue to work together in the future. And as part of that work together in the future, I again want to remind people about the August 26th summit and encourage you to join us there. Thank you.
Thank you, Rosalind. We're a little behind, but I wanted to give each of you a chance to answer one question at least. And maybe we'll start with you, Rosalind. Who are some, thinking back to the work around Section 203 generally, if there you know, other advocates or policymakers, just kind of unsung heroes in this work that you'd want to acknowledge?
Sure. So first of all, in terms of the documentation that was needed to put in the record, we worked on several state-focused reports that were extensive. So the California report was written by Joaquin Avila, who has been a leader, and he's passed, but he was an incredible leader in terms of voting rights work. I would also point out that Nina Perales and Maldef wrote the report on Texas, and Nina and Maldef have continued to litigate extensively on the voting rights. I wanted to do a shout out to the advocates in the Asian American community during 2006. So when the idea of using ACS data rather than the decennial census came up, at least the first people I heard from on this idea was from the Asian American community, of Asian Americans advancing justice. Now, I don't know if they were the first one to come up with the idea, but they are real heroes because they helped amplify it.
Thanks, Rosalind. Why don't we go to you next, Karen?
Yeah, thanks, Roz, for the shout out. Terry Au and I like to think we were the first people who came up with that idea because we were working also on the census side. And we thought, hey, now that we have the ability to do a mid-decade correction, obviously that would be better off in order to serve the increasing population. I would say, you know, one of my heroes is whoever came up with the idea of the threshold, the 10,000 threshold. It's genius because the logic of it is undeniable, right? It didn't make sense that a community with only 500 of language minority in a smaller county could get assistance, but a community of 300,000 in a larger community could not. So I think that made sense to a lot of members of Congress. That just didn't seem to be right, particularly given what the intention was in terms of trying to assist these voters. The second thing is the many volunteers who participated with ALDEF and with CAA and with the Legal Center in the focus groups and in the monitoring and in the research to try to figure out what the different, who could get covered and forecast what the population trends might be, to be able to settle on what that number could be and who could be covered, and to work in coalition together. I think that was so critical. And finally, the voters themselves. You don't often, when you work on the national level, you don't often get to hear about the impact of your work as people on the local level do. And the Legal Center attorneys in LA told me they were monitoring the election after the expansion, right? And they got covered. And they saw an older man come in with his family, and he had a boutonniere on, and he was saying he was so excited to finally be able to go in the voting booth without his daughter and vote all by himself. And I thought that was one of the most moving testimonials about why we do this work.
Thank you, Karen. Henry?
Well, I really am very, very grateful for the leadership of Joaquin Avila on voting rights litigation. He really was a giant in terms of pushing for compliance. And without his leadership, I don't think that we would have gotten as far as we have had, even, especially in the early days. And as I express in my opening comments, we really, truly appreciated what the U.S. Attorney's Office did, especially Amanda Metcalf, an African-American assistant U.S. attorney who had literally, not a whole lot of background about this issue. And prior to the assignment of federal observers, there was very little attention paid to linguistic minority communities. We had read about, during the civil rights movement, the assignment of federal observers in the Deep South, documenting violations and barriers and the like. So really, to her credit, she had the courage to really, just tell, the U.S. Attorney Billy Hunter, we need to do this and find out what is going on. And then lastly, I would say the city assistant attorney, Phil Moscone, who ultimately became a judge, he was actually quite reasonable in trying to reach an agreement. I mean, he knew that the city had done wrong and that it was not to the city's credit to keep on fighting. So in a very tough situation, we were really blessed with key figures who found a way to make it happen to comply with Section 203.
Thank you for those examples. We're going to come back to you all shortly, but now we're going to pass it back to Angelo to give us some information about what states are doing.
Thanks, Raúl. There we go. Thank you. So next slide. So I'm going to cover a little bit. I'm going to cover a bit about what some of the limitations are. But as we've heard earlier, it's important to remember that Section 203 is a remedial statute. It's actually a temporary statute, even though the reauthorizations that we've talked about have been for fairly lengthy periods, 25 years. And but 25 years is coming up in a few years. So the last reauthorization was 2006, 2031 would be the next reauthorization. And it's important, as advocates who work in this already know, that you have to come up with a lot of data, a lot of historical record to show that it is still needed. One of the important developments that we're seeing in a lot of other jurisdictions, state and local government, is that they are trying to expand upon Section 203, not rely on remedial bases, modifying different kinds of things. So couple points here on the slide. If you fall short of the benchmark, the triggers, you're not covered. I'm going to put in the chat a report by Asian American Justice Center. They did a nice job listing just missed jurisdictions, and there's a lot of them that are just short of 5% or just short of 10,000. And sometimes just a handful of people, literally, if you had, and they'll probably get picked up in the next set of determinations, but very close, but a still sizable population. There can sometimes be literacy level issues. Korean Americans, for example, had a higher literacy rate a few years ago. They weren't covered. They eventually were covered in Los Angeles County. The big issue, of course, is that language minority has a very specific definition. It's again based on congressional determinations of past discrimination. So if you look at all the other language groups, which includes among other, this isn't everybody, obviously, but Pacific Islanders, Arab Americans, and other Middle Eastern populations, African, Caribbean, European languages outside of Spanish, indigenous languages from outside the United States, all of those groups are outside the coverage of Section 203. Okay, next slide, please. So what do we see state and local governments do? So typically one or of two different ways. One is just to add a particular language to coverage, and that's often because there are sort of you can't ignore these populations that are in some places because they're quite sizable. Another way is simply to change those coverage formulas. So you lower the benchmark numbers below 5% or below 10,000. You also don't limit it to the language minority definition in the VRA. You either broaden it or you just don't have that kind of specific definition. Okay, next slide. So just as a few examples here, Miami-Dade County, it's covered for Spanish, but they added Haitian Creole, a very big Haitian population in that region. Hamtramck and Dearborn, Michigan, these are suburbs of Detroit, very sizable and politically influential Arab American populations in those cities. Hamtramck was already covered for Bengali, but Arabic was added recently to both of those cities. And as another example, where a number of individual languages are part of the mix, Chicago, Illinois, Cook County's covered for a couple languages, but they've added several of the languages, a couple of which are not covered by Section 203. So if you look at that short list at the bottom, Arabic is not covered, Polish, Russian, Ukrainian, those are not covered formally by Section 203, but the local jurisdiction decided to include those in some of their assistance. Okay, next slide. Okay, so as an example, a lot of you are from California, you know that 14201 of the election code expands coverage in the state. So the benchmark is 3% for coverage. However, it's not the same level of coverage as you might see under Section 203. So sample ballots and voter instructions are translated. There's been an effort, unsuccessful because of a governor's veto, but to expand the types of documents that are available for translation. But clearly a much lower threshold. Next slide. And I will give you an example. San Francisco, which is a city and a county, covered for 2 languages under the VRA, but under the state law, you add another 6 languages, 6 Asian languages, Burmese, Filipino, Japanese, Korean, Thai, and Vietnamese. Okay, next slide. Another example, and this is actually an interesting trend that's happening in a lot of different states, which are State Voting Rights Act legislation. Now, those voting rights acts don't cover just language assistance. They may cover things like developing state pre-clearance or looking at expanding or changing standards to Section 2. If you're familiar with the Voting Rights Act, that's sort of the general anti-discrimination provision where there's a lot of litigation. So the language provisions come in as a part of a package, but there's significant progress that's been made in a lot of states like Connecticut, more recently New York, Virginia, Colorado. Other states are looking at legislation. So as an example, Connecticut has a pretty strong set of language assistance provisions. They've lowered the percent test to 2%. They've lowered the numerical test to 4,000 within a jurisdiction. They don't limit it to language minorities as defined under federal law. They just sort of broaden it to include LEP individuals within jurisdiction. And by the way, you can alter the numerical test by defining a different set of individuals. If you just say LAP adults, that's different from LAP adult citizens, right? So those numbers can be tweaked to make it more broadly covered within a jurisdiction. So within Connecticut, right now under Section 2, we have 10 of the townships. They don't use they have counties, but it's a little bit different in Connecticut. But the townships are covered for Spanish. And when the Connecticut VRA was put into place, 23 additional municipalities, townships, borough, a school district were added for Spanish as well. So there are significant, Native American and also Asian American populations. Probably as things progress in the future and this population growth, you'll see some coverage for some additional languages. So just as a concluding point, one of the advantages of these local and state initiatives and forms of legislation and policymaking is that you get stronger community engagement, both in terms of passing legislation, getting it enacted in the first place, and also just for monitoring. We haven't had a chance to talk too much about how community groups get involved in these in the enforcement and compliance, but it is particularly strong in these smaller areas where there's clear community interest, community involvement, both by voters and community organizations and by legislators. So I think that's a very fruitful area that we're going to be seeing over the next few years, which is state and local legislation that expands upon Section 203. Okay, that's my take.
Thank you, Angelo. So we're going to go back to the whole panel, but first, we're going to play a second short video.
Tenía muchas mariposas. La primera vez que voté, me sentí muy nerviosa. Tenía muchas mariposas en el estómago, pero era algo que yo quería hacer. Es mi derecho y mi obligación como ciudadana. Tenemos barreras lingüísticas, barreras de lenguaje en el sistema. A veces la gente dice ya no quiero hacerlo o se hace demasiado complicado. El lenguaje no debería ser una barrera para ejercer la democracia. Si tuviéramos acceso a boletas en nuestros propios idiomas, elegiríamos y tuviéramos la oportunidad de hacer elecciones aún más fuertes para una comunidad mucho mejor. Cuando todos empiecen a votar, cuando todos se sientan cómodos para ejercer el voto en su propio idioma, quizá California pudiera ser aún más grande de lo que ya es.
Okay, well, thank you for that. And I wonder, maybe Jim, we'll start with you and ask you about where you've seen the impact of this law, and if you can think of some examples.
Sure. So I guess I will say I've had the benefit, both through the work I've done in the department, but also the work I've done in private practice, working with the Native American Rights Fund, of actually working with all 4 covered language groups. But a lot of my litigation work is focused on Indian country, on American Indians and Alaska Natives. And I think that what really came through loud and clear for me in terms of seeing the impact was just focusing back again on the ballot propositions. You know, we found in Alaska, in the 2 cases that we fully litigated there, that far too often you would have ballot propositions that would be specifically affect the daily lives of our clients. They would be limit subsistence hunting and fishing. So literally you're taking food off their tables if a ballot measure passed, but they wouldn't provide language assistance so that voters wouldn't know what they were talking about. And just saying, as a result of the litigation we brought, you know, the ability of people to not only understand, but to even to organize within the communities, to rally around either for or against ballot measures, for or against particular candidates, based upon how they perceive that those individuals would, you know, would represent their communities. And it really has made a significant difference. I mean, there's without a doubt a significant disparity that still exists in terms of voter participation, but that gap is closed a lot. And that's a lot of what we see. I think the other part of this that I hope we get a chance just collectively as a group to talk a little bit more about is, and I think the video that was just on really highlights this point. Participation in the elections is a way of inclusion. It's a way of incorporating people into our democracy. And part of the process of that is continuous education, that we oftentimes see that even with a successful 203 case, it doesn't turn on a dime. You don't see voter participation all of a sudden double. There's a lot of education you have to do in the language to get people to participate. But where you do that, you find that people are very motivated to do so. And so in that sense, the work that all the community organizers do, that all the civil rights groups do every day, it really matters, especially focusing on just the continuous efforts to educate people and get them to participate.
Thank you, Jim. That's a great point. Does maybe Henry, do you want to weigh in here about where you've seen the impact of Section 203?
You know, there's no doubt that Section 203 has allowed many more linguistic minority voters to participate in the electoral process. But that's just only one step. What I think we have witnessed here in San Francisco is, with bilingual, multilingual elections in place for these many, many years, we find that linguistic minority citizens are not only voting, but they're getting politically active, you know, running for office or working as staffers in major campaigns. What I find interesting is we cannot make any assumptions that linguistic minority voters are going to vote in one particular way. They actually span the political spectrum. So without getting into all the weeds, you know, we can have differences within our own communities, which I think is healthy. And I really want to support Jim's argument. We probably do not do enough voter education, because more often than not, many voters say, I just don't know how to vote. And they don't understand all the various elected offices, the boards and commissions, so on and so forth, and ballot measures. So it's an ongoing process to do voter education. I look back at the work that I've done in the past, and I regret that I did not put in more time in just talking about the history of discrimination, because new immigrants, new citizens, they don't necessarily have that background. And it's a constant educational challenge to inform and educate them about the past, why this is important, and then what is the role they can play today, and how they can participate in many, many different ways.
Rosalind, where have you seen the impact for Latino voters?
Well, first of all, I did want to mention that one of the biggest impacts has been the fact that we now have what you might want to call emerging Latino communities being covered, okay? I mean, I think often when people think of the Latino community, they think of it as being concentrated in the Southwest, in Miami, and a few places in the Northeast. But in fact, there are emerging Latino communities throughout the United States. I mean, you know, getting coverage for a place like Milwaukee or Salt Lake City, right? These are all important places where you have growing, robust Latino communities. And it's important that they be able to participate in the electoral process, even if they are not yet fully proficient in English. But I did want to just follow up on one of the things that some of the other panelists, Henry and some of the other panelists, Jim, have mentioned, about voter education. I think when we think about voter education and the impact of 203 for Latinos, we need to talk about this is not just something that's needed for Latinos who are not yet fully proficient in English. We need to combine voter education efforts for native-born Latinos, for native-born folks from language minority communities, because because of educational barriers, because of other barriers, everybody needs to learn a lot more about how to participate in the electoral process. And I think that's one of the other impacts of Section 203, is that it makes us really realize how important voter education and outreach and engagement is for everybody in a community.
Raúl, if I can just interject this one additional point. I happened to be in Milwaukee, Wisconsin this week, helping with community organizer training conducted by the Center on Civic Engagement. So there are more than 80 community organizers from throughout the country, from Alaska to Alabama, Georgia, New Mexico, in the Northeast, Kansas, and so on and so forth. And these community organizers are learning how to conduct voter engagement campaigns. And it is so important that we have community organizers who have those skills to do the voter education, to do the voter mobilization, so that citizens in all these different communities be regular voters. And it does make a difference when linguistic minority voters, along with racial ethnic minority voters, constitute a larger percentage of the vote share in a state. And we have witnessed that happening in the state of Arizona. We have seen the results, that increasing the vote share of Latino voters has been very, very impactful. And it's because of community organizing, use of bilingual materials, outreach, and the like.
Thank you, Henry.
So,
Karen, I wanted to give you a chance to answer this too, but if you also want to weigh in on where you think community groups can help with community outreach into LUP voters, what are good practices? I mean, I think maybe that's where we'll go next too.
okay, great. Well, I would like to tell one story, and this is just one story, but there were many others. And that was when when Harris County, which is the home to Houston, finally got covered for Vietnamese language. And DOJ sued Harris County for not implementing it after they actually started to really fully implement it. It resulted in the first Vietnamese candidate to be elected to the Texas state legislature, defeating a very powerful incumbent by 16 votes out of 40,000. And it was because of the tremendous increase in voter participation by that community. So you can see, and I think he's still in office today, so you could see that in very individually politically, it is helping communities to elect people who are going to be responsive to their needs. And I do feel like it's incredibly important. Laws themselves on the books are meaningless unless communities actually give them life. And it's extremely important for communities locally to go to their election officials, get to know them, talk with them how to most effectively and efficiently do the outreach, to explain to people that, hey, this community really speaks orally, oral translation, this is how it can be done. And in a digital age, right, there's many more opportunities to do it in a cost-effective way and to do the outreach that's needed to make sure that people all use it and also understand why it's there. In the 2006 testimony, one of the election officials said, look, people in these communities actually don't want bilingual ballots. They were offended when they got mailed bilingual materials because they felt that it was stereotyping them as not somehow being American or able to speak English when they could. And I think there, community needs to understand, okay, please don't be offended. Here's the reason why it's necessary. Here's how it empowers your community. That education in and of itself is important, as well as letting people know that it's available. I went to meet with the Lieutenant Governor of Hawaii, who was opposed to the bilingual ballots in Maui, right? And she said, well, no one uses it. I said, well, how do you know no one's using it? And she said, because it all came back all totally shrink wrapped. And I said, well, that means no one opened it, no one put it out there, no one made it available, right? So it's the monitoring, it's the meeting, it's putting the pressure on from, not just right before the election, but throughout the period to make sure that what is happening is going to actually reach the voters that it's meant to reach.
Thank you, Karen. And we'll go to you, Angelo.
Yeah, I mean, just to echo everything everyone has said, I agree. I think the community engagement is critical. If any of you have a chance, I'm not sure what's left on the website of the DOJ, but if you look at some of the lawsuits that were filed over the years, and if you're able to look at a copy, you can see how it is mandated in a very strong way in those settlement agreements that communities must be a big part of the equation. That's litigation, right? So that work has to be done, I think, on a voluntary basis in most places, but that's absolutely critical. How do you know how well these things are actually translated? How do you know that the ballot initiatives are insufficient? How do you know that people aren't getting access to poll workers who can speak their language? All of that stuff has to be in touch with communities, and the communities have the responsibility as well to get engaged too, because these rights can be taken away very easily. And as a reminder, a couple of years from now, it's going to be up for reauthorization. We may or may not see it, depending on how good a job a lot of the advocates who are on this call will be helping to put the predicate together to reauthorize the bill. So I think it's very important to have that kind of community engagement.
And Angelo pointed out something. The poll workers are critical, right? And oftentimes the complaint by the jurisdictions that they can't find bilingual poll workers, and that's something that the communities can really step forward and help encourage people who have the language abilities to do that.
Thank you. Jim, I'll give you the last 1 minute if you wanted to also share further thoughts on the work of community groups, election officials to make the law more impactful.
Sure. So I'll just share a quick story following Karen's footsteps. So during the trial, it was fascinating because one of our witnesses, I won't mention his name, but one of our witnesses who was just wonderful, was limited English proficient in the Alaska native language of Yupik. And he was testifying about how he tried to vote. And then he came to a point where he said, he was asked specifically about judicial elections. Did you vote in the last judicial election? And he said no. And our judge, our federal judge, who was a former state court judge, her ears perked up because judges are elected. They have retention elections in Alaska. And she turned to him and said, why don't you vote? Why don't you vote for the judges? And he said, why should I vote for someone that I don't know and I don't know anything about? And what he ended up going through additional examination explained that there were occasionally judicial candidates that would send campaign materials, like a single-page flyer that would be written in Yupik, and that person would get like all the votes in the villages. And Judge Gleason was not getting any votes in rural Alaska, and she just said, "Oh," like a light came on, and she said, "That's why I never got any votes from rural Alaska." And it's literally one of those things, even separate and apart from the language aspect. It's actually a sign of respect that you're actually saying that your culture matters, your identity matters, who you are every day matters. And that's what our witnesses, our plaintiffs' testimony really drove through clearly to the judge.
Thank you, Jim. I think that's a great way to close. Thank you again to our hosts, and thank you to our panel, and thank you to everyone for joining us today. I hope to see many of you in Sacramento or at the Language Access Summit in a few weeks. And so have a great day, everyone. Thank you all for joining.